Do you want to know the law, the ancient concepts in their own language? Learn the intent of the men who wrote them?
In 1969, a woman, Norma McCorvey, sued the state of Texas, and American politics haven't been the same ever since.
Good evening. In a landmark ruling, the Supreme Court today said that the decision to end a pregnancy during the first 3 months belongs to the woman and her doctor, not the government.
We will not go back to the dark ages.
That is a denial of the right to life, and at the very least is unconstitutional.
Norma McCorvey was suing for her right to terminate her pregnancy. In Texas at that time, that abortion would have been illegal. So she sued the district attorney who was charged with enforcing Texas's abortion ban, Henry Wade. She also filed suit anonymously under the name Jane Roe, and that's how we get the infamous case name Roe v. Wade. McCorvey would ask the Supreme Court to recognize a constitutional right to terminate her pregnancy. To answer this request, the Supreme Court dove into the sporadic and frankly forgotten history of abortion in America.
When you quote Blackstone, is it not true that in Blackstone's time, abortion was not a felony?
But in its 54-page opinion, the Supreme Court finds this ancient legal standard for abortion and takes an acute interest in it. You probably haven't heard of this legal standard. It's hundreds of years old. In the opinion, it's referenced more than any other abortion-related legal standard. It did not become law with the Roe v. Wade decision in 1973, but it might become law in America again this year.
Sir, some new evidence has just been brought to my attention.
There have been age-old definitions. There was a definition of quickening, which was when the mother could feel the fetus moving about in the womb.
Congress is supposed to pass the laws, not the Supreme Court.
But we also need the most basic of rights to choose when and if we will bear children.
This is the context, and this is the second in a series where we're going to break down the most debated Supreme Court case in the past 50 years. Today we're talking about the history of abortion rights and how that history could affect abortion and maternal health in America for a long time.
Elle?
Warner?
I'm sorry, are you here to see me?
No, silly. I go here.
You go where?
Moscow.
For those who are new to the Constitution and the Supreme Court, there's a couple things you should know. First, the Constitution is super vague. It gives judges the impossible task of defining ideals that are enshrined in the document, like liberty and equality. To give you an idea for how vague the Constitution is, the Roe v. Wade opinion that analyzed one clause of the Constitution ended up being 3 times longer than the entire Constitution. The second thing is that although it doesn't always feel this way, the Supreme Court doesn't like to just make things up out of thin air. They like to ground their interpretation of the Constitution in objective reasoning and American history and tradition. For example, in 2008, the Supreme Court identified a Second Amendment right to self-defense. Even though those words don't show up in the Constitution, they dove into the history of gun laws and the language of the Second Amendment to justify the existence of a right to self-defense. For abortion too, the Supreme Court dove into the Constitution and the history of abortion laws in America to see if there was a right to abort one's own pregnancy.
Now, will you give us the facts of the case?
Roe v. Wade started in a Dallas area federal court, but quickly got escalated to the Supreme Court, the highest court in the United States. There, the judges tried to answer this question as to whether there was a right to terminate a pregnancy in the Constitution. The court starts with the history of ensoulment, the point at which a human embryo or fetus gains a soul. The Supreme Court goes all the way back to Aristotle, who believed that early human embryos had a nutritive soul, like a plant, and at some point in the womb transitioned into having a sensitive soul, like that of an animal, a process known as animation. That understanding of ensoulment, a fetus being ensouled at some point after conception and at some point before birth, lived on through early Christian theologians and medieval legal scholars. And that's informative because that history of ensoulment would ultimately inform the English legal system that we inherited from them. In England from 900 to 300 years ago, we start to see reference to fetal quickening. Quickening was and still is the moment that a woman can feel the fetus moving in her womb, usually at about 16 to 18 weeks in pregnancy. It's significant because in early America, one thing is pretty consistent. Before quickening, there simply wasn't a punishment for an abortion that a mother consented to and that did not harm the mother. In 1973, you can imagine the Supreme Court looking at the timeline of a pregnancy and plotting these legal and moral standards on it. They would see some evidence of abortion being illegal after conception. They would have seen the ambiguous range sent by ancient Greek philosophers and early Christian theologians. They would have seen the line drawn at birth by Jesuit theologians. They would have seen state abortion bans cropping up in America, each drawing very different lines for themselves. But here's where the case turns. The Supreme Court said that it saw overwhelming evidence for the allowance of pre-quickening abortions from the most important legal scholars for the founding of the United States and from court cases in the 19th century. Some historians would call this a woman's common law right to a pre-quickening abortion. The Supreme Court believed that that quickening standard was a de facto right of early American women. So they brought back what they believed to be an effective right to a pre-quickening abortion and brought that back in the form of a constitutional right to terminate a pregnancy. If there was an abortion standard that was most prominently known in early America, quickening was it. So even though the Supreme Court seems to have more evidence for this quickening standard than they do for any other abortion-related legal standard, they did not decide to draw the line there. The Supreme Court decided to instead couch that constitutional right to terminate a pregnancy in modern medical language. In Roe v. Wade, they said that a woman had a right to an abortion before 14 weeks and a limited right to an abortion before 27 weeks. In 1992, the Supreme Court moved that line to the point of fetal viability at roughly 23 weeks, or the point where a fetus could live outside of its mother's womb. The Supreme Court clearly didn't feel comfortable reviving this centuries-old legal standard that by the 1970s had long been forgotten. As I'm making this video, the Supreme Court has just heard a challenge to Roe v. Wade, which we'll have an answer for in the summer of 2022. The Supreme Court, with the additions of Justices Kavanaugh, Barrett, and Gorsuch, could be the most conservative Supreme Court we've had in generations. Based on oral arguments, the prognosis for a right to an abortion isn't good. But the questioning also showed that Chief Justice John Roberts was looking for some compromise between liberal and conservative justices, a compromise that has enough historical backing to convince conservative judges of its salience. Roe v. Wade may very well be overturned, but if it stays intact this year, it'll either be with the current viability standard, or it'll be by aligning to a more historically evident standard like fetal quickening. If you're liberal, you might think that this history here is totally irrelevant. Why would we allow 19th century law, a time when women weren't allowed political or civil rights, to dictate what the law is today? Or at the fact that the decision to terminate a pregnancy always involves the health of the mother? Or when we realize that the abortion bans that were primarily passed to preserve the health of the mother no longer serve that purpose? If you're conservative, you probably look at the history of abortion bans and come to a completely different conclusion than the court did. This being abortion, the histories can be incredibly partisan and biased. That makes this topic full of misinformation, which I'll pin a comment on instead of addressing all of that in the video. There are several important features of Roe v. Wade that I didn't mention. We didn't talk about the 14th Amendment and the Due Process Clause where this case comes from. We didn't mention that the justices in this court, much like the court today, was comprised of 6 conservatives and 3 liberals. So next time on The Context, as we continue to break down Roe v. Wade in this series, we're going to ask a question that I've had for a long time. Why do conservative judges like Roe v. Wade?